Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. A copy of the handout can be found in the handout section. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to Henry. You may begin.
Good afternoon, SHRM Long Island. It's September 20th. Fall is quickly approaching, as in, I think it's tomorrow it's supposed to start. So thank you everybody today for joining, signing on, listening. So I'm going to spend most of today doing something that I hope most of you are already familiar with. Some of you might not. These are some of the more recent updates to the anti-harassment law. Some of them will not affect your day-to-day. It'll be more something we look at when we receive inevitably a State Division of Human Rights complaint or a lawsuit or attorney demand letter. Why is this important? Because the standard's lower now in New York State for sexual harassment or any protected category-based harassment. It's going to be easier, and I've done the anti-harassment training now probably close to 200 times in the last few months, but that's a good thing. Happy to do it. Happy to hopefully make workplaces better understand what people's rights are, what harassment is, what harassment is not. For those of you, and this will be probably the only pitch I do of this time, for those of you who are not in compliance yet, that is, you have not trained your employees and your management staff, basically everybody that's under your umbrella in anti-harassment prevention, as New York State and New York City now require. Again, this is statewide. This is not just New York City, not just Long Island. It's everywhere. If you have not done it, October 9th, so we are talking a little less than 3 weeks. October 9th is your deadline. Technically, if you are not trained, you do not have all of your staff trained by October 9th, you will be out of compliance with the new law. There could be fines and penalties, but there's really no good reason why you shouldn't have it done. If you have counsel, consult with them. If you use Jackson Lewis or one of the attorneys in my Long Island office or any of our several offices, please get it on the calendar, get it done. We're happy to help. I'm sure other counsels are happy to help. It's absolutely a best practice, but by law, it must be done, and then we have to do it annually, or it has to be done annually thereafter. But let's at least get the first one by October 9th. So today we'll go over, I apologize for not being more creative on the title. I did my best, and this is what I came up with, the one-stop shop on the New York harassment law changes. So, updated notice requirements. Now, this one's important because this one does affect your day-to-day. It affects what you are giving out at orientation, when you have people completing new hire paperwork, and what you're going to do every year at the training, when what you're distributing, because it goes beyond just a sign-in sheet for somebody to say, hey, I was present. So, already in effect, all employers, New York statewide, and that's going to, unless I say otherwise, presume that everything here is for all New York State employers. That's based, unless somebody here is dialed in from Connecticut or New Jersey or Pennsylvania or somewhere else that's non-New York, assume this applies to everybody that's listening today. All employers must provide employees with a notice containing the two things: the employer's sexual harassment prevention policy, and if you look at that third bullet point, it must reiterate the information presented at the employer-provided sexual harassment training, both in English and the employee's primary language. So the issue with that, and we've had a spirited debate at Jackson Lewis here about what this means, because as you would think, New York State doesn't give you all the information. So there's going to be scenarios where you will have employees who might not have undergone the training because you are just hiring them at that point, and you are supposed to give them the information presented at the sexual harassment training that they might not have taken yet, might not have been subject to yet. So the conservative approach is, if you use training slides, you provide them with the slides even before they undergo the training. Obviously, this really, from a practical standpoint, this really enhances why it's so important to abide by these policies and strictly enforce these policies and make sure that nobody is violating them, and if they do, that they are subject to discipline. So we enforce everything uniformly and consistently, because those slides are going going to include the New York State Division of Human Rights contact information, the Equal Employment Opportunity Commission's contact information, the New York City, Nassau, and Suffolk County Commissions on Human Rights contact information. We're putting that in employees' hands. We're putting it in their hands through their handbook policy where this information has to be mentioned. So it's easier. I mean, forgetting the advancement of the internet and how easy things are, with information at the tip of your finger. It's easier now than it ever was before for somebody an employee, to bring a claim, claiming harassment based on some protected category. So it's just, I cannot stress it enough, to make sure that we enforce our policies across the board, no exceptions. Old cultures where things may have been accepted but were never okay, those things must fall by the wayside and do so immediately if it hasn't happened already. So these notice requirements, they must go out at the time of hire and at every annual harassment training. So it'll be easier at the annual harassment training. You have time to prepare for it, but at the time of hire, shotgun, get ready, get it to them. This should be happening to everybody that you are hiring as you go. You should be giving them a handbook policy or a full handbook and getting a handbook acknowledgement, or at least standalone anti-harassment policy, get an acknowledgement, and the materials that are going to be, or at least what's going to be covered at the sexual harassment training program, even if they haven't taken the program already. Other piece, New York State human rights law, and this is not going to be anything that surprises anybody on this call. It certainly didn't surprise anybody in my office. The New York State human rights law, as most things are in New York, is to be construed liberally. So even if there's laws in the federal realm that maybe have been interpreted differently by the courts or by the legislature, if it's in New York, if it's under the New York State human rights law, we want to make sure that it is intended to be more inclusive, more employee friendly. This is not something that is meant to get employers off the hook. It is a tool for employees to make sure that they are covered and protected from discrimination and harassment as required by the law. And even further on it, any exceptions or exemptions from the New York State human rights law are the opposite, construed narrowly. So we don't want to, create these wide-ranging, diverse exceptions. They're all going to be very narrow to fit a very specific set of conduct, and it's going to be a fact-by-fact or case-by-case basis and very fact-sensitive. But the goal at all times, and for any of you who had the privilege of listening to me speak on paid family leave, remember, paid family leave wasn't a law made to benefit employers. The New York State human rights law is not a law made to protect employers. It's made to protect employees from employers that don't follow the law, from individuals who don't follow the law. And then we have this last piece, the New York City human rights law. Again, you don't look at the other, maybe analogous law from a different agency, city versus state versus federal. You want to examine it under that law. So here we treat the state as the state. We don't compare it to the federal. This is one of the biggest pieces, the lower standard of proof. So this is what's going to make it easier to prove harassment in New York State for individuals. This is, for some of you that are in New York City, this is something that you somewhat already had. New York City already had gotten rid of the severe or pervasive threshold. It is now going to go, at least in New York State. So New York City, I'll go back. New York City is looking at anything that's going to rise above the petty slights or trivial inconveniences, which the courts have interpreted many, many times over the years. Again, it's a very fact-sensitive inquiry. But the federal standard and what the New York State standard has been up until about another 3 weeks, severe or pervasive. So it's we all have seen that interpreted, and we've all always seen those words done around. Pervasive is how often is it happening, depending on what it is, and severe is how bad is the conduct. What are we actually talking about? So that used to be the standard. I guess for another 3 weeks in New York State, still is the standard, not in New York, again, excluding New York City. But now you get rid of the severe pervasive, where you used to have to check one of those boxes if you were an individual. Now individuals will prevail if they are simply able to demonstrate that the harassment subjected them to inferior terms, conditions or privileges of employment because of their membership in a protected class. That is a very, very broad standard left open to interpretation under a law where it has now been instructed that it should be liberally construed, and there's going to be applications by courts. I anticipate applications by courts where what might not have been harassment under the old standard will definitely be harassment now. So we, again, disclaimer again, make sure we are on top of our policies. We give the trainings. We distribute the policies to everybody. The last thing we want to see is, oh, I never got a policy. Oh, my company doesn't have a handbook. Oh, my company doesn't have any policies. Oh, my company doesn't train. Those are all problematic statements. So this Farragher-Ellis defense is something that us defense attorneys have been able to use many, many times over historically. In the last couple of decades, as of October 11th, an employer will now be liable for harassment, even if the employee did not utilize the employer-provided complaint procedure to address such issues. So what we used to say is, we have a complaint procedure. It's in our policy. Here's their policy acknowledgement or their handbook acknowledgement. They knew about it. They failed to do anything with it. They didn't take advantage of it. What were we to do? We didn't know. That used to be a decent defense. Now it's gone under the changes to the New York State human rights law and this new anti-harassment push. So now Farragher-Ellis is gone, which allowed employers to avoid liability for a supervisor's actions if the employee failed to use the company's internal reporting procedures. Now, you should still have your internal reporting procedure. It must, by law, it must be in your policy. You should absolutely train on it. That all applies. But the defense of, oh, it's not our fault, they didn't tell us, doesn't exist. Under city law, employers may reduce punitive damages, so that's damages to punish an employer, where the employer has attempted to detect and prevent the harassing conduct through the use of appropriate policies and training. So there is no kind of comparable language in the state human rights law. I know I just spent 2 minutes telling you how we got to treat each law as its own, but oftentimes a theme of every single one of these webinars I've done is what happens in the city eventually makes its way to Long Island or to the state. So this is something that ultimately maybe we will see, but it's not there right now as far as the ability for an employer to reduce punitive damages. Taking that point to the next level, broadening damages recovery. This is another thing that's going to go into effect in 3 weeks. The state human rights law has now expanded protections against sexual harassment to non-employees. So who's a non-employee? An independent contractor, a subcontractor, a vendor, a consultant, any other third party interacting with the workplace. So now a non-employee, this could be your third party delivery driver, whatever it may be. Non-employee may pursue claims against the company for any discriminatory behavior. Could be discrimination or harassment based on any protected category. And we give a couple of examples, but you could throw in others. You got age, you got national origin, you got color, there's all your disability, several different ones you could throw in. Now, plaintiffs can recover punitive damages. So this is your non-employees. Now, this shows how important it needs to be for our workplace to follow the rules, be by the book, because we don't want to do anything not okay by our policies if we think, oh, they're a third party. What's the big deal? Big deal. This slide is the big deal because now they can come after us. Non-disclosure agreements. So this is a big one that somewhat is disturbing to me, just in the sense of how it's going to change the day-to-day operations, at least in the defense attorney world. It will definitely affect employers. So again, 3 weeks. This was first introduced last year with sexual harassment claims. So any of you who unfortunately were involved in any sexual harassment claims that went to any kind of private settlement with a former employee or even a current employee, you learned that in order to get confidentiality, we needed to start doing separate agreements where it needed to be the complainant's preference to have this confidentiality language. And oftentimes you'd get, if they were represented by counsel, you'd get them to agree, and that's fine. But it gives them an extra time frame. It gives them the 21 days that we normally say, oh, this is how long you have to consider it. Now the 21 days is required. So no one's signed it. It's a mandatory 21-day review period with a mandatory 7-day revocation period even if the person is under 40. So definitely turning some of what we're used to on its head. The problem or the change, I should say, is it's going to now apply to all types of discrimination claims. So it used to just be a sexual harassment concern, but now if it's any, if it's any protected category-based harassment, if it's age discrimination, if it's race discrimination, if it's religious discrimination, disability discrimination, pregnancy discrimination, you name it, sexual orientation discrimination, it's going to cover everything. So anytime we want to settle these claims, we cannot prohibit the disclosure of the underlying facts and circumstances, so we cannot basically get this non-disclosure or confidentiality unless it's their preference. And then when it is their preference, we have to follow the rules we used to for the sexual harassment claims. Prohibition of arbitration agreements. I'll try to speed up to get through these last couple of slides. So again, 3 more weeks. Last year, this we can go quickly on, New York State tried to eliminate the use of these mandatory arbitration provisions. It went up to the courts. I believe it went through the Southern District of New York, which is obviously the federal court in downtown Manhattan. The law now extends to all discrimination claims. However, the one that came up with sexual harassment claims last year, it was ruled that it was preempted by the Federal Arbitration Act, which allows these arbitration agreements. So still, we will hear more on this. It is far from over. I anticipate we'll hopefully get a ruling similar to the one, I think it was in June, from the Southern District of New York on the sexual harassment piece. We'll probably get one on this new piece of the law once it goes into effect and it's challenged, but not there yet, but stay tuned. Extended statute of limitations, again, another big one, August 12, 2020. So this one we have a little bit more time from. It's not in 3 weeks, but now individuals may file a complaint of sexual harassment with the State Division of Human Rights within 3 years. So tripling the amount of time they could do what they wanted to do as far as filing a claim with the State Division. So that 1 year from when when the conduct happened is now for sexual harassment 3 years. So again, if you didn't get the message already, the state is going above and beyond to protect people who are victimized or facing sexual harassment. Other claims, for now, I say that with an asterisk, for now is 1 year. I have no idea what the future holds, but it's, you'd have to be asleep at the wheel to not see the way the trend is going in New York State. Quickly on these last two, we have changes to the New York State Pay Equity Act. So pay equity used to be a gender-based focus. It used to be the examination of the pay difference between men and women. Enough data and research has come out and been realized by Governor Cuomo and his administration that it is more than just gender. That's a distinction in pay differential. We have issues with pay inequity in race, in religion, in color, in national origin. None of those are okay. New York State has caught up to that. So as of about 2.5 or so weeks, the change will be any pay discrimination against any employee based on his membership in any class protected by the New York State Human Rights Law is prohibited. It's unlawful. Claims can be brought. Again, going with the theme before that everything under the New York State Human Rights Law is to be liberally construed, this is that again. Every class is covered. So obviously easier to prove pay discrimination now. So currently, an employee must establish that their job is equal to the job of a higher paid coworker. So equal skill, effort, responsibility, similar working conditions. That's the current standard. With this amendment, employees may also prove pay discrimination, showing that the employer is paying them less for performing substantially similar work. So now some of this is, for those of you that are covered by the FMLA, we're used to seeing, the same or equivalent or substantially similar positions where you have to reinstate them to. But here, showing that the employer is paying them less for performing substantially similar work when viewed as a composite of skill, effort, and responsibility performed under similar working conditions. Once again, a lower standard, a more liberal standard easier for employees or claimants to bring. Lastly, something that I've probably spoken to 3 or 4 times over the last couple of years on the New York State salary inquiry ban. I've spoken to you guys about salary history in New York City. I've spoken to you about it in Suffolk County. I believe I might have even covered it up in for Westchester. But now, statewide. So basically the people that I am focusing on as of now, being that Suffolk's covered and New York City's covered, Nassau County. It's going to go statewide as far as of January 6, 2020. It will be unlawful for an employer to rely on someone's prior salary from a prior job in determining whether or not to offer employment or determining wages or salary of the individual. You cannot, and this is the big one, so you might check your applications, you might have to make changes. You cannot request wage or salary history from an applicant or a current employee. I would hope for a current employee, you already know what you're paying them. If not, we got bigger issues on our hands. You cannot go outside the bounds and try to find their wage or salary history from others. The point of this is to stop perpetuating possible income gaps. Pay people what positions are worth. Don't pay them based on what a former employer may have incorrectly paid them. So again, the bottom is the last, kind of catch-all anti-discrimination piece. You cannot refuse to interview, hire, promote, otherwise employ, or retaliate against an applicant or current employee based on their salary history, or because he or she refused to provide that history, or obviously the retaliation piece because they filed a complaint with the Department of Labor alleging a violation of this law. So Suffolk County, you know this already. New York City, you know this already. Nassau, if you didn't know, now you know. Starting in January, you should make sure all interviewers are trained, make sure your applications are brought up to date. We should not be asking questions as to people's salary history. Salary expectations are usually a different category, but as far as what people used to make at prior jobs, that becomes off limits. So with that, I apologize for going over, but thank you, everybody. I will give my last pitch here. Remember, October 9th, couple of weeks, is your deadline to finish the anti-harassment training to be in compliance with the New York State law. Then we do it annually thereafter. So if you haven't scheduled it, if you haven't done it, please, I implore you, contact us, contact your counsel, whoever you work with, get the training done, check it off, get acknowledgments, get training acknowledgments signed by everybody who participates. I thank everybody for joining today. Have a wonderful weekend. Enjoy, hopefully, the cooler weather, and we look forward to seeing you at the breakfast series next month. Take care, everybody.